subordinate legislation.
G'day
We've already
everybody,
met
and
subordinate
welcome
legislation
to
during this
10
course,
for
and I think
laws
pretty much most of you have an
12063
understanding
advanced
that
statutory
subordinate legislation
drafting
refers to regulations and a
Anthony
range of other instruments which are made
This week we do the third
alongside
and
statute
final of
but are
our
not made
sessions
by the
on
Parliament.
legislative drafting.
If they're made
And we'll
properly,
be looking at
they
drafting
have the same
subordinate
force
legislation
as
We've already
statute
met subordinate
and
legislation
needs to
during
be
this
obeyed
course,
in the same way.
and I think pretty much most of you have an
They give
understanding
executive governments
that
the
subordinate
advantage of
legislation
flexibility
refers to
in
regulations
managing
and a range of other instruments
which are made alongside statute but are not made by the Parliament. If they're made properly, they have the same force as statute and need to be obeyed in the same way. They give executive governments the advantage of flexibility in managing some of the more machinery aspects of statutory provisions. During this week, we're going to look at a range of aspects of delegated legislation. We're going to look at some types of subordinate legislation. We're going to identify the provisions in the principal statute which give rise to the power. And then we'll look at that relationship between the statute and the subordinate legislation. We'll determine the scope of the statutory power, and we'll look at how the statutory power, the purpose of the principal statute affects the ability to make delegated legislation. We'll look at the types of extrinsic material which support subordinate legislation. We'll also briefly discuss the Commonwealth Register of Legislative Instruments, and then we'll have a crack at drafting subordinate legislation for our Student Support Grants Act that we've been dealing with for the last couple of weeks. As I mentioned, we've already in this course previously come across the idea of delegated legislation, but it's worth taking a few moments to review. Delegated legislation is a broad term, and it can refer to quite a range of types of instruments, such as regulations, declarations, proclamations, rules, determinations, or any other instrument by which the Parliament has taken statutory authority and delegated some part of that statutory authority to the executive government, that is, the ministry and the public service. The interesting thing about delegation of delegated legislation is that the Parliament is essentially delegating a core parliamentary function, that is, the making of legislation. Delegated legislation, once made by the executive department, actually has the same effect and the same strength as a law made by the Parliament. But it has no exposure to parliamentary debate and no exposure to the potential for amendment in the consideration in detail stage of that parliamentary debate. So how can we live with this? How can we live with the idea that there are going to be legislative rules made which must be followed by all members of society and which are nevertheless not scrutinised by the Parliament? Well, the answer is that even though delegated legislation is not passed by the Parliament, there is still a process of parliamentary scrutiny. In fact, there are two processes of parliamentary scrutiny in the Commonwealth level and one in the Queensland level. At the Commonwealth level, we've got a Senate committee for regulations and ordinances. The job of that committee is to scrutinise all regulations that are made by the executive government, to determine that they are within the powers that have been established by the Principal Act, and to determine that they do not encroach upon the rights of citizens unduly, and that they do not effectively make such important legislation that in all reality the legislation should be made by the Parliament itself. Beyond that committee, both the Commonwealth and the Queensland Parliament have what's called a parliamentary disallowance process. What this means is that the executive government, once it has made a new piece of delegated legislation, must place this piece of delegated legislation on the table of each parliamentary chamber for 15 sitting days. During that 15-day disallowance period, any member of Parliament, if they wish, can move a resolution that the Parliament disallow that piece of delegated legislation. If such a resolution is moved, then there will be a debate on the resolution and a vote taken. If the vote is to disallow the instrument, then the regulation ceases to exist and ceases to have existed from the moment it was made. It has been disallowed. Now, this, of course, is very rare. It doesn't happen very often at all, because if it did happen often, it would remove the value that the Parliament gets from delegated legislation, which is essentially moving a whole bunch of minor legislative activity off the parliamentary schedule and allowing the executive government to take over. But it does happen, and it does serve as a scrutiny process. So what this means is that when the executive government is making delegated legislation, they're always aware that the potential is there for the Parliament to say, nope, we want to have a debate on this piece of delegated legislation. So there is parliamentary scrutiny, but it is a lighter, softer, less hands-on process of parliamentary scrutiny than you get for a piece of principal legislation. So let's imagine that we're drafting a piece of delegated legislation. What are the things that we need to be thinking about? Well, first and foremost, as the name implies, delegated legislation is delegated. That is, there must be some provision within a principal act whereby the Parliament says, in essence, we hereby delegate to the executive government the power to make rules in this area. If there's no identifiable source of delegation, you can't make delegated legislation. For the purpose of this lecture, we're going to refer to that authorising provision as a grant of power. There are three questions that we should be asking ourselves as drafters before we start drafting delegated legislation. The first question is, what's the purpose of the grant of power? The second question is, what are the limits on the grant of power? And the third question is, what are the preconditions that must be met before the grant of power can be validly exercised? Let's start with the first of those, the purpose of the grant of power. Normally, when making delegated legislation, it's not simply enough to read the words in the grant of power and go ahead and make delegated legislation without looking any further. It is always necessary to ask yourself the question, what is the purpose of the principal legislation? What is the purpose of the act which has given rise to this delegated power? Because it makes sense that the delegated power can really only be used in accordance with the purpose of the act. If you started using the delegated power for a purpose that the act hadn't contemplated, there would be a really good reason for people to sit up and say, hang on, this power is being used in a way that wasn't contemplated by the act. It shouldn't be used in that way. If you want to use this sort of power, you should go back to the Parliament and have a debate. The example that I'm using for considering the purpose of the grant of power comes from a case called South Australia and Tanner. Now, I'm not sure how many of you have been to the township of Harndorf north of Adelaide, but if you ever get the opportunity and if you're at all inclined towards these things, it's well worth the day trip out of Adelaide. Harndorf is essentially, as its name suggests, is essentially a little slice of Germany in South Australia. Lots of German beer halls and cafes and lots of shops with German themes. It's become a real tourism attraction in recent years, the township of Harndorf. In Harndorf, there was a company or a firm that wanted to develop a walk-in aviary. So a large aviary in which birds would be kept and that tourists could come and walk around inside and have the birds flying around with them. Thing is, of course, they had to get all of the necessary planning approvals. The other thing is that Harndorf sits in a river catchment area. Now, there is a regulation in place relevant to Harndorf which says that it's not allowable to operate a zoo in that particular river catchment area. The question is, of course, is an aviary the same as a zoo? Now, bear in mind, we're not just talking about a backyard aviary. We're not talking about a hobby type aviary. We're talking about something on a grand scale, and something where the purpose of the aviary is to encourage tourists to come and see the animals. Is that the same as a zoo? Well, a zoo was defined in the regulation to mean any building, enclosure, yard or structure within which any animals, birds, reptiles or any creatures whatsoever are kept primarily for the purpose of display. Now you can see there's a few bits and pieces in that definition. The first bit is any building, enclosure, yard or structure. Well, is an aviary a building, enclosure, yard or structure? I would say that it pretty clearly is. Within which any animals, birds, reptiles or any other creatures whatsoever. Now, of course, some of you are thinking about our Latin maxims of statutory interpretation to work out what might be meant by other creatures whatsoever. But we don't need to look at that bit because the definition quite clearly refers to birds. And the third element is kept primarily for the purpose of display. In this case, the birds are clearly being kept for the purpose of display. So the local council said, no, we're not going to authorise the building of this aviary because we're concerned about the impact that the keeping of those birds might have on the river catchment area. The developers appealed and it ended up in front of the High Court. The fundamental question for the High Court to decide was whether or not the aviary was properly described as a zoo for the purpose of these regulations. How did they work it out? They worked it out by considering the purpose of the statute. Now the statute, remember, was all about water quality in the water catchment. And so the High Court was considering whether or not the keeping of an aviary with many birds for tourism purposes was such a venture that it may have an impact on water quality in that water catchment area. And they decided that it was. And they decided that the regulation was in fact in place to try to further the purposes of the Principal Act. As a result, the regulation was upheld and the ruling of the council was upheld and the aviary could not proceed. So you can see how important it is to make sure that a regulation is written in such a way that it quite clearly furthers the purposes of the statute. How do we tell the purposes of the statute? Well, we go back to all of those intrinsic and extrinsic guides to interpretation that we've been talking about right through this course. We'd be looking at the long title, we'd be looking at purpose sections, we'd be looking at explanatory memoranda, we'd be looking at second reading speeches. All of these things that tell us about what the purpose of the Parliament was in passing that piece of legislation. They are our guides as to what we should and should not be doing in terms of drafting regulations. So we've considered the purpose. The second thing we ought to be considering is whether there are any limits on the grant of power. If the principal legislation sets specific boundaries, delegated legislation cannot proceed beyond those boundaries. Remember, public servants have no inherent right to make regulations. They can only do it because the Parliament has said so by passing a statute which allows a grant of power to make regulations. If that statute contains restrictions, the public servants, the executive government, have no option but to live within those restrictions. Typical restrictions that you might see might include limits on penalties and limits on timeframes. An example that I've given in the notes is the Keno Act 1996. I'm sure you're all aware of what Keno is. It's sort of like a continuous lottery game that you see in pubs and clubs. Now, the Keno Act allows the Governor of Queensland to make regulations, and the regulations are able to impose a penalty. The penalty can be no more than 20 penalty units, which is a little bit north of $2,000. Now, what that means, of course, is that if the Governor purported to make a regulation which imposed a penalty of 30 penalty units, that regulation would be invalid. It would be beyond the limits of the grant of power. So as drafters of delegated legislation, we need to be asking ourselves, are there any limits expressed in the principal legislation on the regulations or other delegated legislation that can be made under this Act? If such limits are in place, then the drafter of the regulation must abide by them, or else the regulation will be invalid. The third thing to think about is preconditions. Sometimes a delegated power is only enlivened under certain circumstances, and if we attempt to use that power under any other circumstances, the power will be invalid. So, for example, under the State Counter Disaster Organisation Act in Queensland, there are a whole range of powers that come into effect when a state of emergency is declared. If a state of emergency or a state of disaster is declared, then a whole bunch of extra powers can be exercised. A state of disaster is determined by the Governor in Council. So that is the Governor on the advice of the Ministry. However, before the Governor can declare such an emergency, two conditions have to be met. First, there has to be an actual or impending disaster. An actual or impending disaster, that means there must be a cyclone off the coast heading towards the towns for which the declaration is about to be made, or there must be floodwaters lapping at our ankles, or the bushfire must be bearing down upon communities. So there must be an actual or an impending disaster. And the magnitude or threat of that disaster must be so great that it goes beyond the resources of a single disaster district coordinator. Now what that means is that if there's no actual or impending disaster, if there's the possibility of a disaster in a week or so, but it's not actually impending, or alternatively, if there is a disaster, but it's not a huge disaster, it's something that can be managed at a district level, then the Governor's declaration of a state of disaster would be invalid. It would be an invalid exercise of power because the preconditions for that grant of power would not be met. Now in Queensland, this famously became the subject of some serious politics in the early 1980s. Those of you who are as old as I am will remember that in 1982, Brisbane hosted the Commonwealth Games. Now, the Commonwealth Games, along with the World Expo, which was hosted in 1988, are really regarded within the culture of Queenslanders as being the two events that transformed Brisbane from being a fairly sleepy town, much of the sort that Adelaide is still regarded as, into being one of the major cities of Australia. The Queensland government under Premier Joh Bjelke-Petersen in 1982 was extremely concerned to make sure that the Commonwealth Games went off without a hitch. The Bjelke-Petersen government had already had experiences of major sporting events being disrupted by protests, when protesters, anti-apartheid protesters, had protested against the tour of the Springboks rugby union side in the 1970s. As a result, the Bjelke-Petersen government sought to declare a state of emergency for the period of the Commonwealth Games in order to give police and similar officials extra power in order to ensure the success of the Games. That is, in order to overcome any protesters, particularly Aboriginal land rights protesters, who were expected to be very prominent during the Games, and they were expected to be particularly prominent because the Queen was expected to be in Brisbane. Now, they did pass that legislation, mainly because the Bjelke-Petersen government had a strong majority in the Legislative Assembly at that time. However, it was necessary for them to go back to the Parliament to get that power, because there was no impending disaster. So instead of being able to do this by a quiet regulation, it had to be done in the full glare of parliamentary scrutiny, reported on by the media, discussed by Queenslanders everywhere. It was a big issue at the time. So you can see the only way that they could extend the power in that situation was to go back to the Parliament. They couldn't just use the power as it was, because the preconditions for the exercise of the power had not been met. So as drafters, we're asking ourselves three questions. What is the purpose of the legislation? What limits does the legislation impose? And third, what preconditions does the legislation set out before regulations can be made? Once we've done that, drafting regulations is not actually terribly difficult. Here are my hints. First and foremost, everything that you've learned in recent weeks about drafting principal legislation also applies to drafting regulations. Most importantly, however, don't reinvent the wheel. This is the only time in your university career that you will hear a university lecturer say to you, plagiarise, plagiarise, plagiarise. Find similar delegated legislation and use it as a model. Keep in mind, though, that the delegated legislation you're using as a model should be recent. And by that I mean really within the last 5 to 10 years at the very most. The more recent, the better. The reason for this is that drafting styles for delegated legislation change very rapidly. And so if you're using as your model a regulation that was made in the mid-1970s, it's going to look positively archaic compared to the other delegated legislation that's now being made. The only additional thing that I can really tell you about drafting delegated legislation is that it's important that you focus on practicality. You see, the whole idea of delegated legislation is that it takes the little bits and bobs that are necessary in order to make the principal legislation come to life, the bits and pieces that are likely to change regularly through the operation of the Act, and it pulls them into one place. The purpose of having the delegated legislation is to provide practical assistance to those who are exercising the powers under the Act. So you want everything within the delegated legislation to be as practical as possible. Let's have a go, shall we? In recent weeks we've been looking at the Student Support Grants Act 2013, or the bill for that Act. Now let's say that we've submitted our draft bill to the client. The client's very happy. We hear on the grapevine that the bill has been sent off to Cabinet, which is the meeting of the Ministry, who will determine, you remember from earlier weeks, will determine whether or not the bill goes off to Parliament. You suddenly get an email that says, Cabinet has now approved the Student Support Grants Bill to go ahead in the next sitting of Parliament. This is great news, but it means we have to get moving on the regulations because they'll need to be drafted and ready for proclamation soon after the Act commences. We are hoping the Act will sail through both Houses of Parliament perhaps even as non-controversial legislation. Consequently, please draft regulations to set the amount of the grant as follows. Students with an HD average or better, $2,500. Students with a distinction to high distinction average, $1,800. Students with a credit to distinction average, $1,500. Students with a pass to credit average, $1,200. And students with a fail average will get a grant of $0. In addition, please establish the following additions to the base rates. Aboriginal or Torres Strait Islander students to get an extra $500, external students to get an extra $500, and parents returning to education or to the workforce will get an extra $500. Finally, please draft a regulation requiring students to submit receipts to show that they've spent the money on IT equipment. Now, what do you think? What do you think of those instructions? Well, let's go through the process. First question, what is the purpose of the grant of power? Well, the purpose of the grant of power, as I recall it from the drafting that we did in recent weeks, is to provide students with a grant of money to assist them with their IT needs. I don't recall anything in that purpose which links the need for the grant to academic performance. It is assumed that students will have the same need for information technology regardless of what academic results they're actually obtaining. Second, I don't really remember anything in the Act that suggested that certain categories of students, such as Aborigines, Torres Strait Islanders, external students or returning parents, would have additional needs that should result in an additional grant. I don't recall anything which would suggest that that's within the purpose of the Act. So already I'm starting to feel pretty dubious about these instructions. I'll push on though and ask about the limits on the grant of power. Now, the grant of power as we drafted it last week didn't include any specific limits. However, I'm starting to wonder whether or not provisions which would provide an extra surcharge or provisions which would require students to submit receipts would be within the limits of that grant of power. Because I'm fairly certain that if we recall exactly what the provision said last week, exactly what the delegation, the regulation making power said, that it was limited just to setting the actual amount. In fact, it said the Governor-General must, by regulation, fix the amount of the student support grant. Do you think we can require students to submit receipts? I can't see anything in that grant of power that would allow us to require students to submit receipts. Let's continue on though and take our third consideration. Preconditions on the grant of power. I can't really see any preconditions on the grant of power in Section 9 of the Act that we drafted last week. So we don't really have any problems there. But gee, I'm worried about whether or not what we've been asked to do is actually within the limits of the power that was granted to us in the legislation. And I'm also worried about whether or not making those regulations would be within the purpose. So I don't know about you, but I wouldn't be drafting these regulations. I would think that that is probably going to be wasted effort. So I would go back to them with an email and say, the instructions that you've given me are not instructions that I can comply with, because the regulations that I would have to draft would have to be invalid. Now let's say we win that argument. Now we can undertake the actual process of drafting. Let's say they come back and they say, all right, just do what you think best. Well, what I think best is that we stick to the actual grant of power, which says the Governor General may set the amount. So let's set the amount. We start by looking at other pieces of legislation. Just hunting through, using keywords, the same sorts of searches you've done for ages and ages and ages. Eventually, in my own searches, I came across the Criminal Code Animal Valuers Regulation 1999. Nothing to do with student support grants at all. But it's got a regulation in there that says the total fee payable for each day or part of a day on which inspections or valuations or both are carried out is $200. Now that sounds pretty close to me to what we're trying to accomplish. We can muck around with the words and get away with something as simple as the amount payable to a recipient of a student support grant is $1,800. Even simpler, we could just say the amount of a student support grant is $1,800. Seems easy enough, but can you see that the process by which we came to this easy answer was actually quite long and involved? Finally, when we're actually drafting the regulation, it's always useful in the actual body of the regulation to link back to the initial piece of legislation. Don't leave anyone guessing as to which section we're claiming the power came from. So in this case, for our regulation, which is in the notes at section 7.4, it simply says, in three little sections, the amount of a student support grant is $1,800. Very simple, good plain English drafting, but with a great deal of research and a great deal of consideration behind it. And sometimes that's the way of good drafting. You can spend hours and hours and hours on a piece of legislation which looks absolutely puny at the end of it. The final thing I want to talk about in terms of delegated legislation is extrinsic materials. Extrinsic materials for regulations can be just as important as extrinsic materials for principal statutes, because at the end of the day you may still have debates going on in court about what the specific meaning is of a regulation. There are a range of extrinsic materials you can use. These days, most forms of, particularly regulations, but most other significant types of delegated legislation will come with what's called an explanatory statement. This is pretty similar to an explanatory memorandum for a bill, but it's tabled alongside a regulation. Clever, savvy public service departments will issue an explanatory statement alongside any regulation which they think might be a little bit controversial, in the hope that by providing that explanation up front, they may prevent the need for a disallowance process in order to have a debate to have those questions answered in the chamber. In addition to that, however, we can look around and find some other useful extrinsic sources of information relating to delegated legislation. One that comes to mind is policy statements by the executive government. Now, in a legislative context, we don't normally give too much credibility to policy statements because there's a long road between executive government policy and a piece of actual legislation. However, for delegated legislation, where the executive government's the one actually exercising the power, The road is much shorter. So a policy statement by the government may actually be very useful in helping us to understand the background behind a piece of delegated legislation. Third, don't forget the political context. Ask yourself, what is the executive government trying to achieve by making this regulation at this time and by making it with this context? Fourth, think about the materials extrinsic to the principal legislation. It may well be, for instance, that the explanatory memorandum, whilst principally referring to the legislation, also mentions something about what is expected to be contributed by the regulations. Similarly, the second reading speech or parliamentary committee debate might make reference to the expected role of the regulations. This is something you should know if you're drafting those regulations. And finally, if the regulation was passed and there was a parliamentary debate, that is, there was a disallowance motion and there was debate on that disallowance motion, that's something important for you to know if you're trying to interpret the regulation. It's worth finding out through the Hansard when that regulation went through the Parliament and checking to see whether there was a disallowance debate. If you do all of those things, then you'll know as much about the regulation as the person who drafted it, and you'll be in an excellent position to be able to interpret it successfully for your clients. Well, at this point, we're at the end of quite a long road. We spent the first few weeks of this semester talking to one another about the use of language and about drafting technique in general. And we spent some time looking in great detail at some of the techniques of statutory interpretation. With those two bodies of knowledge behind us, we've now spent a few weeks looking at the drafting of principal statute, that is, operative clauses, machinery clauses, defence clauses and exception clauses, and now we've looked at the drafting of regulations as well. At this point, you have the basic skills required to lay down a full set of simple legislation. In the final 2 weeks of this course, we're going to step away from legislation and we're going to look at some of the other drafting that you'll be required to do much more often as practicing lawyers. Next week, we're going to be looking at correspondence and affidavits, and then in the final week of our course, we're going to be looking at contracts and wills. We're almost there. I hope you've enjoyed this 3-week step in to the process of parliamentary drafting, of legislative drafting, and I'm looking forward to taking it into the world of private practice next week.